Hello aspirants, welcome to Spardha Line. In today's session, we are going to start the fundamental rights. We are going to see this fundamental right, the whole chapter in 2 or 3 parts. Okay. So before going to our actual discussion, I will just give some the facts related to fundamental rights. So when it comes to fundamental rights, these fundamental rights are that included or inserted in Indian Constitution in Part 3, and the article that starts from Article 12 to Article 35, and these are articles, they are divided within the on the different dimensions that we'll see through the MCQs. Now when it comes to fundamental right, the one word that we actually hear, that is the fundamental rights, these are the Magna Carta. Now when it comes to Magna Carta, the meaning of the word, the Magna Carta is the divine that, or the document that given by the charter document given by the British king, that King John in 13th century, beginning of 13th century, it's around the 1215, the King John, he given the Magna Carta to the people of England. Okay, and this Magna Carta, which included the rights like such as political liberty and the other social right. So that's why when the fundamental rights are included, so it is called as a Magna Carta. Second aspect, this fundamental rights, it is taken from the USA. It is inspired from the USA Constitution. So this is the one more important fact. Other important fact that we need to know is these fundamental rights, they are not absolute, but they are justifiable. Why they are not absolute? Because the parliament has given power to impose reasonable restriction on their enjoyment. So this is related to fundamental rights, and these are justifiable because after their violation, the person, citizen of India, in some instance the foreigners, okay, the aliens, they can go to the Supreme Court or High Court. Okay, under when it comes to Supreme Court under Article 32, and when it comes to High Court under Article 226. So this is some basic facts, other facts that we'll see through the actual MCQ. So we'll start our discussion with the first question. So the first question is the fundamental rights are guaranteed by the Constitution to all persons without any discrimination. Second statement is the fundamental rights are meant for the promoting ideals of the political democracy. Third statement, the fundamental rights in the Indian Constitution are more elaborate than those found in Constitution of any other country or the other country in world. Okay, pause the video, answer the question. Now, many people will wonder about this first statement. Okay, many of you would have made it. It said that it is the wrong statement, but it is not wrong. It is the correct statement, because the fundamental rights by the Constitution, they are given to all people without any discrimination, because Constitution itself says that the equality, talks about the equality, talks about the liberty, and it puts reasonable restriction, but it did not discriminate people based on any criteria. And these reasonable restrictions to make the peoples to enjoy their dignity and protect the unity and integrity of nation. So when it comes to the fundamental rights, they are available to all citizens without any discrimination. So this statement is correct. Second statement, the fundamental rights are meant to promoting ideals of the political democracy. Okay, how the ideals of political democracies are enforced? It is enforced through the liberty, and fundamental rights are very crucial to for this liberty. Okay, for this through the liberty, people gets opportunity to develop their individual personality. Okay, also as well as this liberty, it is the citizens or the rights of citizens are non-constrained by the state. So indirectly, the fundamental rights, they are putting the or they are keeping check on the tyranny of government or the executive. So that's why it is called as they are to promote the ideals of the political democracy. Third statement, the fundamental rights in Indian Constitution are more elaborate than the found in Constitution of any other country. Yes, this statement is correct. So the correct answer is D part of all the statements are correct. Okay, we'll move towards the next statement or next question. You see, it is talking about the definition of state that in Indian Constitution. The Constitution of India explicitly defines the term state for the purpose of Part 3 and Part 4. Even a private body or agency working as an instrument of the state falls within the meaning of state under Article 12. So pause the video and answer this question. We'll see the answer. So the first statement, if we see, it is about the Constitution of India explicitly defines the state, term the state for the purpose of Part 3, that is for purpose of enforcing fundamental rights, and the Part 4, that is for the DPSP, Directive Principle, State Policy. For these two purposes, the Constitution of India, it defines the state. Now what constitutes states? State according to Constitution, it is about the union. When it comes to union, it includes the parliament, that is legislature, union legislature, and the union government, that is union executives. Second, when it comes to state, same, it includes the state legislative assembly, state legislative council, as well as the state executives, that is chief minister led by the or chief minister with the council of minister. Again, it includes the local governments, which are Panchayat Raj institutes, urban local bodies, district bodies, and other the boards that are governing the local governments or doing the local function. Again, it also includes the statutory corporations. These statutory corporations which are established by the state, that is be it union government or the state government. So these all are included in the definition of the state. So the first statement is correct. Second, the private body or an agency working as the instrument of state falls within the meaning of Article 12. So this is the interpretation of Supreme Court in case called Rajasthan State Electricity Board versus Mohanlal and Sukhdev Singh case. So in these two cases, the Supreme Court interpreted that the state, when the particular private body or agency, it works as an instrument of state, so it has given the test, that the test of control, if the control lies with the government, the function, the body, the agency, private body or agency, it is performing state function, and the fund, if they are getting fund from the state, then these all are considered as a state. In these two particular cases, Supreme Court said. So the second statement is also correct. The correct answer for this is C for cat. Both 1 and 2 statements are correct. We'll move towards the next question. It is about Article 13. It talks about, it expressly provides for the doctrine of judicial review. Second statement, Article 13 declares that the constitutional amendment is not a law, hence cannot be challenged. Second statement, the legislative and non-legislative source of law can be challenged in the court as a violating of fundamental rights. Okay, pause the video and answer this question. Okay, so we'll see the statement here, question here. First, it talks about, it expressly provides the doctrine of judicial review. Okay, because what Article 13 says, it talks that all the legislature or the instrument that government is bringing, they must align with the constitutional provisions. Okay, or if not, they are not aligning, then it is considered as void. And who will decide this void? That is the Supreme Court, High Court in India. So it is clear that the Article 13, through the text of Article 13, which talks of, which says that the any law which is not compliant to provisions of Constitution, it is a void. And through this, we can say that it, Article 13, it expressly provides the doctrine of judicial review. Okay, so first statement is correct. Second statement, Article 13 declares that the constitutional amendment is not a law, hence cannot be challenged, because this is the part of the conflict between the judiciary and the state when it comes to the establishing supremacy of fundamental right over the DPSP. And in this series of the conflict, there was one amendment, particular amendment brought by the government. It is called 24th Constitutional Amendment. And this particular amendment says that the definition of the law that given under Article 13, it will not constitute Constitutional Amendment Act. So our Constitutional Amendment Act will not be included in definition of the law. For this purpose, it is changed the subject matter of Article 13 as well as Article 368. Okay, so this is the case, and this particular amendment is considered as a void. It is considered as valid by the Supreme Court in Keshavanand Bharati case. But same time, Supreme Court said that if it is violating the basic structure of the Constitution, which is propounded by Supreme Court in the Keshavanand Bharati case, if the particular law that is violating the basic structure of the Constitution, then definitely it will be challenged. So it depends on interpretation that the Article 13 declares that the constitutional amendment, it is a law, it is correct, but it hence cannot be challenged. Okay, but if it is violating the basic structure doctrine, it can be challenged. Okay. Third statement, the legislative and non-legislative source of law can be challenged in court as a violating fundamental rights. Now the legislative source means whatever the statutory acts that government is bringing. Okay, so these constitute the legislative acts, and non-legislative means the customs that prevalent in societies. So this comes under the non-legislative acts. Okay, and the both, be it customs or the statutory acts that are violating the fundamental rights, then they can be challenged in Supreme Court and the High Court. So third statement is also correct. Second statement, based on the interpretation, it is the wrong. The correct answer is A for apple. 1 and 3 are correct. Okay, we'll move towards the next question. It is about the fundamental rights available to citizens and not to foreigners. So which of these articles or the fundamental rights are available to citizens but not foreigners? Pause the video and answer the question. So the correct answer for this question is the, if we see Article 14, the equality before law, it is available for the foreigners or not? It is available for the foreigners, but not, so it is not comes under this particular aspect, that is it is not available only for the citizen but available to foreigner. So this is not correct answer, correct option. Second, Article 15, which prohibit discrimination based on the religion, race, caste, sex and place of birth. Okay, so when it comes to place of birth, if some foreigner person, okay, if he is claiming something in India, okay, and if we allowed to non-discriminate based on the place of birth, then he will enjoy all the right as citizen without being the citizen or invoking citizenship of India. So for that purpose, the Article 15, it applies to only citizen of India but not to foreigners. Third, also Article 16, which talks about the equality of opportunity in matter of public employment. The only Indian citizens are non-discriminated based on the religion, caste, their creed, sex, place of birth, okay, and their descent. But foreigners, they can be discriminated. So this particular article, it is available to only citizen of India, not the foreigner. Article 17, abolition of untouchability. It is available to foreigners as well as citizens, because abolition of untouchability, it is not just fundamental right available to citizen of India, but it is the one of the universal law, because all are humans that they are born free, and the universal law, it talks about the equality of all the animals, all the humans before the law. So if person is discriminated based on his birth in particular caste, so be citizens or the foreigner, he will be enjoying this Article 17. So this is not correct option. Next, abolition of titles. This particular aspect, this particularly prohibit the state, the Indian government, to confirm titles on the citizen of India as well as the foreigners. So the citizens also enjoy this right, as well as the foreigners also can enjoy. So this is also not correct option. Last, Article 19, it talks about the protection of certain, like freedom of speech, freedom of association is there, freedom of movement is there, freedom of livelihood or the freedom of occupation is there. These all are articles available, rights are available to citizens of India only, not to foreigner. So the correct answer for this question is A for apple. 2, 3 and 6 only are the correct, other are wrong. Okay, we'll move towards the next question. This is talking about the Article 14. Okay, the Supreme Court held that where the equals and the unequals are treated differently, Article 14 does not apply. Second statement, it permits reasonable classification of person, objects, transaction by the law. Third statement, arbitrary, artificial and evasive classification is permitted under Article 14. Pause the video and answer the question. So we'll see what can be the correct answer here. When it comes to first statement, the Supreme Court held that where the equals and unequal treated differently, Article 14 does not apply. What is Article 14? It is the equality before law. And when it comes to equality before law, we consider this is the only part, but there is second part, that is the equal protection of law. When it comes to this equal protection of law, it constitutes that two people can be considered equal only when they are similarly situated, or their class standing or their standing in society, it is the same. That term only they can be considered as equal. But when it comes to equality before law, irrespective of their standing, irrespective of their economical standing, political standing or the social standing, all are the equal before law. So it is not gives any scope for the our that social justice. So and it is can be enforced to the equal protection of the law. Okay, so this interpretation of Supreme Court, it is upholds this particular aspect, that the equal protection of law. So that's why it says that where the equal and unequal treated differently, Article 14 does not apply. If the two people are the different based on their class standing and government discriminate between these two people, the government gives the more benefits to lower class or poor, then the rich people or the upper class people, they cannot claim the Article 14. So this is the interpretation of Supreme Court which it with respect to the equal protection of law. Second statement, it permits reasonable classification of the person, object, class, transaction by the law. This statement is also correct because the Constitution, it prohibits the class legislation. Okay, Constitution, it prohibits the class-based discrimination, but it prohibits the classification of the persons. The person can be treated based on their class, based on their caste. Okay, so based on their caste, they can be or their standing, they can be classified based social and educationally backward class. So this is the one interpretation that can be classified. Okay, when it comes to objects, this also same applies. Transaction also same thing applies. So that's why the second statement is also correct according to Supreme Court. But last statement, UPSC, the arbitrary and artificial evasive classification is permitted. It is not permitted because whatever the classification of person is there, it should be based on the scientific criteria. Then only the classification can be upheld as a right or the valid in the Supreme Court. So third statement is wrong. Correct answer is A for apple. 1 and 2 are correct. We'll move toward the next question, which is about Article 15. So Article 15, it statement talks. The Article 15 allows discrimination on the grounds of other than religion, race, caste, sex, place of birth. Second, it is positive in character because it limits the state's power. Third statement, Article 15 prohibits discrimination both by the state and the private individual. So, quite tricky question, but pause the video and try to answer it. Okay, we'll see the question here. Now, if we read the Article 15, it says that the people should not be discriminated based on their religion, race, caste, sex, place of birth only. So this is the one word added in Article 15. So now there are two terms. The discrimination. When it comes to discrimination, it prevents the distinction of the two people based on these criteria, and only on these criteria. These only words. It means the discrimination other than these criteria, the religion, race, caste, sex, place of birth, it is allowed. So this is the interpretation of Article 15. Second statement, it is positive in character because it limits the state's power. No, it limits the state character, but it is not positive, but it is the negative in character. When it comes to the feature of fundamental rights, there are some fundamental rights which are negative in character. Negative in character means they limits the power of state or the government, and there are certain fundamental rights which are the positive in character because it gives the certain power to citizens. Okay, if it is giving certain power to citizen against the state, then this fundamental right classified as a positive one, and which fundamental limits the power of the state, they are classified as a negative. So the second statement is wrong. Third statement, the Article 15 prohibits discrimination both by the state as well as private individual. This is the correct, because Article 15 there are the two provisions, same text, but it says that the non-discrimination based on this ground, it applies to the state. Okay, in common sense. And when it comes to the private individual, Based on these same grounds, religion, race, caste, sex, place of birth, the private individuals also, they cannot discriminate Indian citizen from accessing the common public property. Okay, the restaurant. Okay, again the well that are for the common purpose. So these are, when it comes to the common public properties or common public or the accessible, the which are the places which are accessible to all the people. So in these places, the private individuals also cannot discriminate with the citizens based on this criteria. So the third statement is also correct. So correct option for this, B for ball, 1 and 2 are correct. We will move towards the next question. It is about the EWS reservation. So it talks about reservation of EWS was implemented on the recommendation of Major Sinha Commission. Economically weaker section are to be identified by the state from the time to time on the basis of family income. Okay, pause the video and answer the question. So we'll see the question. The reservation of EWS was implemented based on recommendation Major Sinha Commission. The statement is correct. The EWS reservation, it is came through the 103rd Constitutional Amendment 2019. You can remember 1, 2, 3, 3 numbers are there, and there are also 3 letters EWS. When it comes to backward class, it is the 102nd. So this 2 is there, 2 number. This particular number is 2, and the backward class, it is also have the 2 words. So this, through this you can remember. Okay, these are the how you need to, you can remember it. So 103rd is applies to through the 103rd reservation EWS category. They got the 10% reservation in the government jobs as well as educational institute. And these EWS, who are the EWS people? Those who, the people who are not covered in OBC, SC and ST reservation. Okay. Second thing, the Supreme Court in Indira Sawhney case, it said that there is a 50% ceiling on the reservation, but it can be breached in some extraordinary circumstances. But when the again this particular the EWS case happened, that time Supreme Court interpreted this 50% ceiling, it applies to reservation for the OBC, ST and SC, not for the other category. So the if government is giving reservation other than the OBC, ST and SC, the government can breach the 50% ceiling. So this is the one fact related. Second statement, the economically weaker section are to be notified by the state from the time to time on the basis of family income. Yes, this statement is correct, because it is they are notified by the state governments and based on their family income. What is family income? The family should not hold more than 5 acres of the land. When it comes to the municipal areas, municipality, notified municipality area, they should not hold the more than 100 square yard plot. When it comes to the other than municipality, it's about the 1000 square meter. Okay. Also, for the purpose of EWS certification, the properties in different place, these will be combined, and it will be calculated whether it falls under this criteria or not. Okay. And this all applies to the particular family. If the family of the 4 person, mother, father, the son and daughter, so these family of 4 people, all the people combinedly or the separately holds more than 5 acres, then still they are not considered as EWS category until and unless the son or daughter, they are more than 18 years of age. Okay. So this is the one more fact you need to remember. Next question. It is about Article 16. it talks about the appointment of the office bearer in any religious and denominational institute can be restricted to persons of that particular religion or the denomination. Second statement, the state can provide for the reservation of appointments or the post in favor of any backward class that is not adequately represented in the state service. So pause the video and answer the question. So we'll see what is the correct answer. The appointment of office bearer in any religious denomination institution can be restricted to the person of the particular religion or the denomination. This statement is correct. The Constitution, the Article 16D, it talks about this particular right, that the office bearers of particular denomination or the religious institution must belong to that particular religious denomination or that particular religion. Second statement, the state can provide for the reservation of appointment in or the post in favor of any backward class not adequately represented in state. So this is also correct, and this provision added by the 77th Constitutional Amendment Act. So the second statement is also correct. The correct answer is C. That is both 1 and 2 statements are correct. Next statement, next question. It is about Article 17. This article talks about the Constitution of India defines the untouchability and forbids its practice in all form. Second statement, the untouchability includes the practice like social boycott, exclusion from religious service for any reason. Third statement, Article 70 available only against private individual and not against the legal persons. Pause the video and answer the question. So the correct answer for this question is we'll see the statement first. The Constitution of India defines untouchability and forbids its practice in all forms. It does not define the untouchability, but it forbids its practice in all forms. This second part is correct, but the first part is wrong. So first statement is wrong. Second statement, the untouchability include practice like social boycott, exclusion from religious service for any reason. Okay, so this is again one more interpretation is there when it comes to untouchability. When it comes to untouchability, it is defined by the subject matter of the untouchability is defined by the Madras High Court. Madras High Court says that the untouchability is a historical discriminatory process, and where the persons they are discriminated based on their birth in particular group. Okay, so the word birth is important because in the same case Madras High Court says that the untouchability not involves the social boycott. Okay, because the social boycott which is not because of their birth, if it is because of their birth in particular, social boycott is because of their birth, then it will be included in untouchability. But the others, social boycott not based on the birth of the person in particular group, then it is not considered in untouchability. So the untouchability include practice social boycott, exclusion from religious services for any reason. When it comes to the birth, then only it will be included in untouchability. So the statement is correct. Is wrong because it is not only the based on the birth, where when the discrimination or boycott or exclusion it is based on their birth, that is that time only it includes in untouchability. Last statement, Article 70 is available only against the private individual, not against the legal person. It is not correct, because untouchability is available against the private individual as well as legal person. Now legal person, in Article 14, the Constitution says legal person comes, they are the corporations or the entity which has legal existence. Legal existence in the sense it has taken recognition under the certain legal laws or the legal provision. So that time it is called as legal person. So the third statement is also wrong, and the correct answer can be the options are correct. The only one is the correct option. Okay, and again based on the interpretation, the question is. We'll move towards the next question. It is about the Article 18. It prohibits the state as well as the citizen of India for granting, accepting only hereditary titles of nobility. Article 18 upholds the principle of equal status of all the citizens. Last statement. Words of merit such as Bharat Ratna, Padma Bhushan are excluded from the purview of Article 18. Pause the video and answer the correct question. Correct answer. Okay, so when it comes to Article 18, it is about abolition of titles. And what kind of titles it abolished? It has imposed, it is the positive in nature, because it is it puts the restriction on the rights of citizen, as well as it is, and gives they give them certain privilege. Also it is negative in nature, because it puts the limits on authority of state. Okay, when it comes to abolition of title, it applies to state as well as the citizens. When applies to state, it is prohibit the state to not confirm the titles on citizen, and these titles which are the hereditary titles of nobility, only hereditary title of nobility. State can confirm the titles of merit. Okay, so which kind of comes? The Padma Bhushan, Bharat Ratna, which are based on the merit of a person, not his ancestry or not his hereditary title. So this is the one aspect. Citizens also, they are not allowed to accept any titles of hereditary of nobility, but they can accept the titles of merit. Okay, so the first statement, if you see now, the prohibit state as well as citizen for granting accepting only hereditary titles of nobility. So statement is correct. Second statement, it upholds the principle of equal status of all citizens. Correct, because it is Article 18, it prohibits the only hereditary titles. So there are the people, all will not be belongs to any royal family or the political family. So there are the certain people who will become, who belongs to the erstwhile royal family, not now. Okay, so now they enjoys the hereditary title of nobility. So if they are enjoying certain hereditary title, then the titles come with certain privilege. Now what will happen? The imbalance in status will happen. So this is the one aspect. So it is indirectly uphold the principle of the equal status of all citizens. So this is the hidden aspect of the Article 18. Next, the words of merit such as Bharat Ratna, Padma Bhushan are excluded from purview of Article 18. Yes, because the person is allowed to accept the titles such as Bharat Ratna, Padma or Padma awards. Okay, but they should not use as a prefix. Okay, they should not say that Bharat Ratna XYZ. They should not say that Padma Vibhushan XYZ. So this is the one aspect there. So the third statement is also correct. Correct answer is C for cat. 1 and 3 are sorry. All the three statements are correct. Correct option is D. Okay. We'll move toward the next question. It is about the which of the following not included in freedom of speech and expression under Article this 19(1). Okay, 4 options are there. Let me know which is not included. Okay, we'll see the question because it's quite tricky. The correct answer is the B, that right to information. Because according to Supreme Court, right to information comes under Article 21, not in Article 19. Okay, so in this one case that led to the right to enactment of right to information, there Supreme Court says the right to information is it upholds the personal dignity of a person. So it is interpreted under Article 21, not under Article 19. When it comes to the freedom of silence, yes, it comes under Article 19, under the freedom of speech and expression. Second, right against the Bandh, it also comes under the Article 19, freedom of speech. Okay. When it comes to freedom of press, it is one of the medium. Press is the one of medium to enjoy the freedom of press, freedom of speech and expression. So this also comes under. When it comes to the, many of you would have been confused. In Article 19, it covers citizens' right to know government activities. Okay, these parts covers under Article 19, but when it comes to right to information, it covers under Article 21. So this is the small catch and the trap here. So be very careful when you read the M. Lakshmikan, and it is given in M. Lakshmikan under Article 21. That is, it has given the list of the liberal interpretation of Supreme Court of Article 21. So you can go through it. Next question we'll see is about the freedom of assembly. Every citizen has the right to assemble peaceful without arms. The state can impose reasonable restriction on grounds of incitement to offense. Okay, pause the video and answer the question. Okay, we'll see what is the correct answer here. First, every citizen has the right to assemble peacefully without arms. This is correct. Now, if I tell you, the state can impose reasonable restriction on grounds of incitement of offense. This is wrong, because when it comes to freedom of assembly, the state can impose a reasonable restriction based on only two grounds. First is sovereignty and integrity of India. Second, maintenance of public traffic in area concerned. So based on these two grounds, Supreme Court can, the government can restrict the right to enjoy the freedom of assembly. But this incitement to offense, it is the one of the reasonable restriction in the freedom of speech and expression. Okay, so next time when you read the M. Lakshmikan, be very careful which reasonable restriction comes under which of the fundamental rights. Okay, this is the trap which UPSC might keep, because it is talking about without arms, and the second I'm talking about the incitement to offenses. Many people will connect these two because logically both the statement seems true. Okay, so we'll move toward the next question. Again, it is about the freedom of association. It says, originally Constitution guaranteed all citizens the right to form association, union, cooperative societies. Second statement, the citizens have complete liberty to form the association or union for any objective and purpose. Third statement, the right to obtain recognition of an association covered under the Article 19 as a fundamental right. There is one more statement here, fourth one. The right to strike is a statutory right given to the citizen of India. So pause the video and answer the question. So we'll see the question here with the statement. Talks about originally the constitution guaranteed all citizens to form association, union and cooperatives. Till here, the originally constitution has given right, but when it comes to the cooperative society, it is given by the 97th Constitutional Amendment Act. So the originally constitution has not given fundamental right to form the cooperative society. So the statement 1 is wrong. Second, the citizen have complete liberty to form association, union for any objective and any purpose. The statement is correct. Okay, they have the liberty to form association, union and cooperative for any purpose or objective. It should be the morality is the reasonable restriction here. Okay, so kindly remember this. Next statement, the right to obtain recognition of association covered under Article 90 of Fundamental Right. No. The right to obtain recognition to any association, any union or any cooperative society is not a fundamental right. Only right to establish is a fundamental right. Okay, and it also covers the right to establish as well as the right to continue and right to not to join. So there are the three dimensions of the right to form association, but this particular is not covered under as a fundamental right. Last statement, the right to strike, statutory right. Yes, it is a statutory right to citizen of India under Industrial Dispute Act that came in 1947. Under this act, the workers or the citizen of India, they got the right to strike, and this is the statutory right because it is given by this particular law, not by the constitution. So last statement is correct. So the correct answer for this is the, how many statements are correct? 1, 2, only 2 statements are correct and 2 are wrong. So B is the correct answer. We'll move toward the next question. It is about the freedom of profession, occupation and trade and business. So it says the citizen have the right to practice any profession, carry on any occupation, trade and business. Second, no objection can be made when the state carries a trade, business, industry, service as a monopoly. Third statement, the state can prescribe the professional or technical qualification necessary for practicing any profession, occupation, trade and business. So pause the video and answer the question. We'll see the correct statement. We'll see one by one. All citizens have right to practice any profession, carry or any occupation, trade or the business. Statement is correct. Okay. Don't confuse if it's mentioned any. Okay. Until and unless the profession is immoral, the right to or the freedom of occupation is remains intact. Okay. So this is the interpretation and this is the exact text of the this particular freedom of occupation. Second, no objection can be made when the state carries a trade, business, industry, service as a monopoly. Yes, it is directly linked to the nationalization of businesses or the heavy industry. Also, it is directly linked to the public interest. Okay, so these are the aspects involved here. Okay. And also it involves the national security. Now the production of nuclear energy, it is solely done by the state. Until recently government opened for private sector, but due to national security criteria it is kept as a monopoly of the state. Next, last one, the state can prescribe professional or technical qualification necessary practicing any profession, occupation, trade or business. Yes, it can tell the for any technical qualification for the any professions. Okay, professions such as a doctor is there. Okay, the scientist, occupations such as which are linked to the hazardous industries, Okay, so these are the government can prescribe the professional qualification. So the last statement is also correct. So correct answer is D. All are the correct. We will move toward the next question. It is about Article 20. So it talks about the Article 20. It grants the protection against the arbitrary excessive punishment to an accused person. Second statement, this right extend to citizen, foreigner, legal person like companies or the corporation. Pause the video and answer the question. We'll see which is the correct one. The Article 20, it grants the protection against arbitrary excessive punishment to the accused person. Okay, because it is the protection given against the conviction. Okay, so once if a conviction happened, okay, that person can be given the punishment, but the arbitrary and excessive punishment cannot be given to accused person. So the statement 1 is correct. It also given the right to extend citizen, foreigner, legal person like companies and or corporation. Yes, because Article 28 is not only involves the criminal laws, it includes the civil laws. Okay, so when it comes to corporation or the companies, there are some civil laws. Okay, like imposing taxes. Okay, it should not be arbitrary or the all the on based on the whims and will of the state. So that's why the second statement is also correct. So this particular protection given to the companies and corporation to protect them from this arbitrary tax laws. So the correct answer is C. Both are correct. Next question is about Article 21A. Okay, 21A. It is about the right to education. So the 86th Constitutional Amendment Act 2002 inserted provision related to right to education in fundamental right, directive principle, and the fundamental duties. Article 21A makes only elementary education fundamental rights, not a higher or professional education. Third statement, the right to education under Article 21 is subject to limit of the state's economical capacity and the development. Okay, pause the video and answer the question. Okay, when it comes to this right to education, okay, the people will be confused because the right to education, it is included in Article 21 and as well as Article 21A. UPSC, KPSC, they might not ask, they will not confuse you, but in by chance if the situation comes, if they ask under which article this particular right to education like covers, if they given you these two options or other, like they gave the other fundamental rights, you should mark the Article 21, sorry, Article 21A, because this is the enacted by the 86th Constitutional Amendment in 2002. When it comes to the Article 21, this interpretation of Supreme Court, it is based on the Unni Krishnan case. And this case is happened in 1992. In this particular case said, Supreme Court said that right to education is the fundamental rights for the citizen under the Article 21. And it says that elementary education as well as the higher education, these are the fundamental rights. So in the question case, Supreme Court included elementary as well as the higher education. But same year in 1992, there was one more case. It was the Mohini Jain case. In this particular case, Supreme Court rejected that higher education cannot be included in the right to education, but it upheld that the elementary education is a fundamental right of the citizen under Article 21. But ultimately, government came with 86th constitutional amendment, which inserted Article 21A as a fundamental right to education. And also with this, it inserted directive principle, Article 45. Actually, it is changed at a subject matter, not included, because previously what was there? It is obliged the state to give the elementary pre-education to children between the 6 to 14 years. Okay. So now it is changed the subject matter. It says that till the age of 6, it is state's duty to provide them quality life, or the quality whatever the need is there, it should be fulfilled by the state. So okay, so this is changed the subject matter. When it comes to fundamental duties, it is inserted Article 51, the last article, that is sub-article K. Okay, it is included duty of the Indian citizen to provide the elementary education or the primary education to their children, their wards, or their other, like the children whom they are taking care of. Okay, so this is included the article in 51K, 51A K. Okay, so this is the about the fundamental right. So this statement is correct. Now the second, Article 21 makes only elementary education fundamental rights, not a higher or professional education. Correct. But in uniconstitutional case, Supreme Court said the higher and professional education also part. But according to Constitution, when the 86th constitutional amendment, it is inserted Article 21A. It said that the only elementary education is fundamental right, not a higher education or the professional education. So that's why the statement is correct. Last statement, right to education under Article 21 is subject to limit the state's economical capacity development. And this is interpretation of Supreme Court in the case called Mohini Jain case. Okay, it is depends on economical capacity of the state. So the third statement is also correct. Correct answer is D. That is 1, 2, 3. All the statements are correct. We'll see next question. The question is about, with reference to provision of Article 22 of the Indian Constitution, consider following. It's about the preventive detentions available against both the citizen as well as available to both citizen as well as aliens. The detention of a person cannot exceed 3 months unless Parliament prescribe otherwise. Third statement, the grounds of detention should be communicated to the detainee. Fourth statement, the detainee should be afforded opportunity to make the representation against the detention order. Okay, read the statements carefully. Quite tricky questions are there, tricky statements are there, and answer the correct option there. So we'll see which is the correct statement. First is a preventive detention available to both to citizens and aliens. This is correct. When it comes to Article 22, that protection against the detention, so it frames the two parts. First is punitive detention, which is against the ordinary laws. Second is about the preventive detention laws. Okay, NSA is there. Okay, other laws, UPA is there. So these laws comes under the preventive detention law, and this particular second aspect is available to both citizen as well as the alien. So this statement is correct. Second statement, detention of person cannot exceed 3 months unless Parliament prescribe otherwise. This is wrong, because it is not a Parliament, it is the advisory advisory board of the High Court. So Parliament, okay, it will provide only the circumstances, okay, under which circumstances the 3 months period can be exceeded, but ultimately the advisory boards will give the final call. Also, Parliament can tell that the maximum period, okay, so what can be the maximum period that person can be detained? So previously it was 3 months. 44th constitutional amendment, it is brought to 2 months, but ultimately it is not implemented. So currently the what was the previously was there before coming 44, that the 3 months, that is still continued. And also Parliament can describe the procedure that to be followed by the advisory board, okay, but it will not itself decide on the person will be detained for the more than 3 months or not. So this is the one aspect you need to read the very carefully. Third statement, ground of detention should be communicated to detainee. Second statement is correct. The detainee should be afforded an opportunity to take represent against the detention order. This is also correct. Until and unless the public interests are involved, okay, until and unless public interests are involved, the grounds of detention should be communicated with the person who detained. Also the detainee, he should be afforded opportunity to make a legal representation or the representation against the detention order through the, and also he has the access to legal practitioner. So these are statement correct until the public interests are available, are involved. So all the statements are correct. C is the correct option. We'll move towards the next question. It is about the Article 23. Okay, it talks about the Article 23. It is prohibit forced labor and enforce against the both private, individual as well as state. Working for less than minimum wage is considered forced labor under Article 23. Pause the video and answer the question. We'll see which one is the correct statement. First statement is the Article 23 prohibit forced labor and is enforceable against the both private individual as well as the state. Statement is correct because the private individual, the forced labor, it is the traditional extension of traditional practice, that is begar, that was prevalent during the Gupta period. Okay, and the previous also there was this particular practice was prevalent. And now when it comes to the state also cannot force the person to work or forced labor. Also the private individual, they cannot buy or sell the people. They cannot involve in human trafficking. They cannot support the Devdasi practices. They cannot support the slavery. So these are all the practices that is done by the private individual. That's why the private individuals are also included under the purview of this Article 23, that right against the forced labor. Second statement, working less than the minimum wage is considered forced labor. Statement is correct because the word, the force, in forced labor, the word force, it is physical force, it involves a physical force, okay, that the person should not be physically forced to work, okay, without any compensation. Also it involves a economical circumstances, because under any economical circumstances the person cannot be forced to work than the minimum wages. Okay, so this is the important catch you need to remember. So that's why the both statement are the correct. Next statement we'll see, next question. It is about the Article 24. Okay, it says that it does not prohibit employment of children in harmless and innocent work. The Constitution bans the employment of the children, domestic servant, and business of establishment. The Constitution provides establishment of the National Commission and the State Commission for the protection of child right. Pause the video, answer the question. We'll see which one is correct one. First statement, the Article 21, it does not prohibit employment of children, harmless, innocent work. Statement is correct because the Article 21, it prevents the child labor in the factories, mines, and other hazardous industries such as the railway, construction business, but it not explicitly prohibit employment in harmless and innocent work. That is, the son or daughter of farmer, they can work in agriculture activity apart after their school hours. Okay, so this is the part of their daily life and it is not prohibited. Even the small businesses, small carts, the people, mostly the vendors, they run the small carts, their children's the help comes to help them, and this is particular practice is not prohibited under Article 24. The Constitution bans the employment of domestic labor, servant, and the business establishment. No, not a Constitution, it is the government. In 2006, it is banned the employment of children as domestic servant as well as the business establishment. So the statement is wrong. The Constitution provides establishment, National Commission, State Commission for protection of child rights. Not constitutional, there are the statutory law. It is newly enacted in 2015 with same name, Protection of Child Right Act. In 2015 it came, which gives the, before that also it is amended actually in 2015. And actually Supreme Court has given direction in 2006 to state or the government to establish commissions for the protection of child rights, and that after that the child through the statutory act, National Commission and State Commission of Child Labor protection of child rights established. So the third statement is also wrong. The correct option is the B, that is the one is correct one. So with this we are finishing today's discussion. Tomorrow I will come with the part 2 where we are going to see again the discussion. Again we'll start from Article 14 and we'll see the till the end. Okay, today I am finishing discussion. Thank you very much.